All right, so today's workshop, I've titled it Intellectual Property, Protecting and Leveraging Your Inventions, Brands, and Creations. So before I get started, I'm obligated by attorney professional conduct rules to give a disclaimer. And actually, I just wanted to move everybody's video is off to the right. It's blocking. Oh, there we go. All right. Okay, back to the disclaimer. The material that I'm going to present in this workshop is for general information purposes only and is not intended to be, nor should it be considered as legal advice or counsel. No attorney-client or confidential relationship is formed or created by way of this presentation between myself and any of the participants, obviously. And if you have a specific IP legal situation you're interested in, I suggest you seek advice from competent counsel. All right, so let's get started. Intellectual property. What is it? I mean, it's a term we hear all the time. It's thrown about quite a bit, but really, what is it? So you can think of it as several different things. It's an umbrella term for four related yet different types of legal protection. And I'm going to go through all four of those types in this presentation. Those would be patents, trade secrets, trademarks, and copyrights. Another way to look at IP is it's creations of the mind having recognized legal property rights. IP, the various categories or types, they all have the characteristics of intangible personal property. It's not tangible or physical like a real estate or a car. And because it has the attributes of personal property, albeit intangible, people can sell their IP rights, they can assign or transfer them, or they can license them. In other words, give someone permission to practice their IP rights. Some IP rights, particularly patents, they may require a quid pro quo from the creator to obtain legal rights from the government. And I think, as we've all seen, it's a hot topic right now. Businesses are, they're recognizing and taking steps to protect and exploit the value of their IP. And we see a lot of articles today where IP has become greater than 50% of the overall assets of many, many types of businesses. I just saw somewhere an article earlier this week where one study they did said that IP now constitutes 84% of the overall assets of a business, and where now the tangible assets like machines and other hard assets, they're only comprise 16% of the total assets of the business. All right, so let's go on to the next slide. Generally speaking, the four types of IP are patents, trade secrets, trademarks, copyrights. Here's some shorthand ways of looking at each one of these. Patents you can think of as new ways of making things or doing things. In other words, inventions. Trade secrets cover secret ways of making things or doing things. Trademarks, their purpose is to identify who sells things or does things. In other words, it's someone's brands. And copyrights deal with expressions of ideas or creations. With these four types of IP, they tend to be easy to confuse. You often hear misnomers where people say, I want to patent my music, or I want to trademark or copyright my new invention. So hopefully, as people get more educated about IP, they'll understand how to use the terminology correctly. The various types of IP, they tend to be territorial in nature. So each country's procedures and laws are different. For example, the various laws of the United States that cover the different aspects of IP tend to be very different than the laws of the various European countries, which tend to be different than those of Japan or South Korea or China. So There's no worldwide IP rights for any type of patent, or IP rather. So there's no singular patent right worldwide. There's no trademark rights worldwide, certainly no trade secret rights. Probably the one area or aspect or type of IP that comes the closest to worldwide IP rights are copyrights. And I'll talk about those later. Also, there are differences in the start of legal protection, even within the United States, and then comparing the United States to other countries. Legal protection can start upon creation of the various type of IP, versus the legal protection doesn't start until the applicant applies for the IP rights, and it's either a simple registration process or they have to go through a more elaborate examination, then a registration process. There's also differences in length of the legal protection between the various types. Some have a finite time period, like patents, issued patents. Other aspects or types of IP, their protection is theoretically infinite if someone is still using and protecting that IP. Differences in penalties for non-authorized use by others. I think we've all seen when we rent a movie, you know, a long time ago when we rented it at Blockbuster, or today when we just call up a movie by demand, one of the first things we see on the screen is this warning that if we copy this movie, you know, bad things are going to happen to us. We face a $250,000 fine and 5 years in jail. Other types of IP have strictly civil penalties, like patents, for instance. If you think someone's infringing your patent, you can't call the local police or the FBI or anybody like that. It's strictly a civil action between you and the entity that you believe is infringing your patent rights. Finally, there's differences in governing law. Here in the United States, some types of IP are governed strictly by federal law, and that's most notably for patents, whereas other types of IP are governed by state law, sometimes by themselves or in conjunction with federal law. All right, so why does someone pursue IP protection? Now, some good reasons here. One, you want to protect what you've created. You've invested a lot of time and money and energy. You really have a dream of starting your business. You've been through the accelerator programs at E4All Holyoke or VVM or elsewhere. And you know, you've sacrificed a lot. So you want to protect that investment. Also, you want to deter and stop theft by others. What I mean by deter is if you suspect someone is stealing your intellectual property, you can, or to deter someone from stealing your intellectual property, you can use warning notices and other notices like the TM and the registered R in a circle, trademark symbols, or the C within a circle, copyright symbol. Stopping theft by others, you can send them a cease and desist letter and even take the drastic step of filing a lawsuit against them. Another reason to pursue IP protection is to give your business a competitive advantage. You have something that your competitors want and need. Typically it's your discriminator, be it technology or some brand name or logo or something like that. So you want to protect your market share. So you get as many IP rights to protect your business as possible. Another reason is you pursue IP protection to realize higher prices for your goods and services. Basically, you know, when you have IP and it's good, strong IP rights, you tend to stifle to some extent competition for the products or services that you offer in the marketplace. Other reason is to generate income from licensing or selling your IP. You may have some IP that for whatever reason you're not using it anymore, or even if you are using it, you make a decision where you feel you can generate revenue from that IP by letting someone use that IP in their business. So you license them, or maybe you have some technology that for whatever reason you're not using it anymore. So you want to sell it. There's active markets for patents and other proprietary types of information as well. So, and finally, a good reason to pursue IP protection is it makes your business more attractive to investors. They like IP. We see it on Shark Tank all the time with early stage funding. The sharks are always asking, do you have a patent, et cetera. And then also for exit strategy, you want to cash out and either start another business or retire early to an island in the Caribbean or whatever. IP obviously enhances the value of the business that you're trying to exit from. All right, so let's start in on patents. We can think of patents as a contract between the government, in this case, the federal government, and the patent owner. So in any contract, there's consideration flowing from each side, or a quid pro quo. The government gives the patent owner certain rights of exclusion for a period of time. In exchange, the patent owner, which is oftentimes the inventor, or it can be the inventor's assignees or employer, or whoever is owning the patent at the time, the patent owner gives a full written disclosure of its invention within the patent. So why do we do this? Well, a full disclosure to society by the inventors of their technical innovations, it's in a publicly available document, but it benefits society as a whole. So, the underlying premise of the patent system is people everywhere can read the patent and improve upon the invention that's disclosed in it. And it advances the overall body of scientific knowledge that's available to people throughout the world. But if the government didn't give these rights of exclusion to the patent owner, then the patent owner, for example, the inventors, would have little incentive to publicly disclose their invention because they have a natural fear of someone with bigger and better resources stealing their idea and profiting off of it. And this concept of rewarding an inventor by giving him or her legal rights of exclusion, it's not a new legal concept. We've had patent laws here in the US since 1790, and this concept actually goes back to Europe in the 1400s, and I've even read somewhere where it even goes back to Greece around 500 BC, so it goes back a ways. All right, what is patentable subject matter? The US Supreme Court, in a case from 1980, they came out and said that it's anything under the sun that is made by man. And that's key, made by man. So the statutory categories in the appropriate section of the federal law there's 4 of them. It's a machine, an article of manufacture, a composition of matter, or a process or method. And you can think of machines as something having a lot of moving parts, in contrast to an article of manufacture, which has no moving parts or very few moving parts. For example, like a coffee mug where you can take the lid off of it. That would be considered an article of manufacture instead of a machine. Then the 3 category or criteria that you have to, or hurdles that you have to overcome to get a patent to issue is the subject matter. It must be novel. In other words, it can't be known throughout the world. It has to be non-obvious, which means that even though the subject matter is novel, the differences between the subject matter and the difference between the subject matter and what you're trying to patent or what you've invented cannot be obvious to one of ordinary skill in the art. And then it must be useful. Usefulness or utility is usually the easiest of the 3 hurdles to overcome. And if we're dealing with design patents instead of utility patents, we're talking about the design has to be original. So again, now, what is not patentable? Well, you cannot patent a result. So you can't just patent the let's say you're trying to invent a COVID vaccine. You can't patent this, the stated result of preventing someone from coming down with the COVID disease. Instead, you patent a means or a method for achieving a result. Then also these next three ideas, these have been the subject of a lot of current controversy, but the courts have said that abstract ideas, laws of nature, and natural phenomena cannot be patented. And so currently, one hot topic is software, which has kind of gone back and forth really over the last 25 years since software was first deemed to be patentable subject matter. Then it's fallen out of favor, and now it's somewhere in between. But currently, a method that you embody in software, let's say that runs on a computer, it may be considered as non-patentable, or typically is considered non-patentable subject matter because it's an abstract idea. For example, you cannot patent a general purpose computer alone programmed to operate in a certain way. However, if you claim the software correctly, you can get a patent to issue. In other words, the patent office will say that yes, it is patentable subject matter. So why not? Why can't we patent abstract ideas, laws of nature, natural phenomena? Well, because they're considered to be basic building blocks of science, technology, and knowledge in society. So it's really not fair for all of us in society for someone in particular to have exclusive rights in an abstract idea or law of nature for any period of time. However, if we try to patent a device, or we can patent a device that's obviously novel, non-obvious, and it's useful, if it operates according to an abstract idea or law of nature or natural phenomenon. And let's move on to the next slide. So
Rick,
in the United States,
I'm sorry to interrupt you. We had a quick question in the chat. Sure. Diane wanted to know, are seeds a natural phenomenon?
They are, I believe. However, there's, I'm going to get into it shortly. There's really three types of patents. There's utility, design, and then there are plant patents. And you can get a plant patent if you discover or invent a new type of asexually reproduced plant. So, that covers flowers, vegetables, fruits. So in other words, it's genetically engineered. There's not, in my 32 years, I've never had a client who asked me to prepare a plant patent application for them. They've only been around since 1930, and I think we've only had about 30,000 plant patents issued since 1930. But yeah, I think a seed would be a naturally occurring thing. So if you didn't create the seed by, let's say, genetically modifying an existing natural seed, in other words, you didn't create a man-made seed, then you can't get a patent on the seed itself. Okay? Does that answer your question, Diane?
Yeah, thanks.
Okay. All right, patents in the US. It's an examination and registration process. We in the United States, the term we use is the US Patent Office issues patents. You'll hear a different term in other parts of the world, and particularly Europe, where they say the patent office is, let's say, of Germany, they grant the patent. They don't issue it, they grant it. So I'll get into the details later of the application process, but basically you have to prepare and file an application with the US Patent and Trademark Office, or the USPTO as we often refer to it. And then that application gets examined for novelty, non-obviousness, and utility. If you get a patent to issue, it's only enforceable in the US, its territories and possessions. So you can't go waving it around up in Canada or Mexico or anywhere else. But we'll get into some of the finer points of that later in this presentation. And a patent cannot be renewed once it expires. It has a finite lifetime, and once the patent expires, you can't renew it. So we see that a lot in the context of pharmaceutical patents, where you may read about a patent for blood pressure medicine, where that patent is owned by a pharmaceutical company like Pfizer or someone else, let's say. They get a patent on it, and the patent I believe it's 15 years, or I'm sorry, for pharmaceutical, it's the 20 years from the issue date. So during that 20 years, it's, the pharmaceutical company basically has a monopoly on that drug or pharmaceutical, and they can basically charge whatever they want to charge, per pill or per dose or whatever. But then as the patent is nearing the end of its lifetime, all these generic drug companies are gearing up to make the generic version of that drug. And then once the patent expires, like the next day, these generic drug companies are there to have their generics on the market at a much lower price than what the original patent owner sells its pharmaceuticals for. So once the patent expires, like I said, pharmaceutical companies are lining up to sell their generics, which it means in general that the technology that's described in the patent claims, or the claims portion of the patent, can then be used by anyone without fear of infringement or without having to pay the patent owner a license fee. So there's 3 types of US patents. There's utility patents, there are design patents, and there are plan patents. So the utility patents, they cover the structure and function of a product, or how a process works. So in other words, for a product, how is the product built, what's its structure, and how does it operate? Utility patents are by far the most common type. Since they started putting numbers on utility patents in 1836, we're up to just over 10,800,000 utility patents have issued. And by the way, the first patent was issued in the United States in 1790. But between 1790 and 1836, for whatever reason, the United States government didn't assign patent numbers to them. So, or at least not in the sequential numbering system that we have today. So the term of protection, in other words, for the rights that are given by an issued patent, is 20 years from the issue date, or from the filing date rather, I'm sorry. But these rights don't spring. In other words, the patent isn't enforceable until the patent issues. So if you file a patent application, and for whatever reason that application doesn't mature into an issued patent, you don't have those rights of exclusion afforded to you. There's an exception here where when you file a non-provisional patent application and it gets published at 18 months from the earliest filing date, then, and typically it takes more than 18 months after you file a non-provisional application to get it to issue as a patent. But between 18 months and the day it issues, let's say 24 months after the earliest filing date, if that patent issues, you can have some provisional rights later on where if you sue somebody for infringement, you can not only collect damages going back to the day the patent issues, but you can go back to the day the patent application was published, and you can collect the reasonable royalty from the infringer. Couple of rules that apply to that is the patent that issues has to basically have the same claim or claims that was in the application as it was published. And oftentimes those claims change from the time they're published to the time the patent issues. Also, you have to provide, you as the patent owner after the patent issues, you have to provide actual notice to the infringer that that infringer is infringing your patent. Another characteristic of utility patents is 3 times during the life of the patent, you have to pay maintenance fees in order to keep the patent in force. 3.5, 7.5, and 11.5 years after the issue date, you have to pay these fees. If you don't, the patent is going to lapse. And then once it lapses, the technology described or claimed rather in the claims portion of the patent is available for anyone to use without fear of infringement or having to pay a license fee. A lot of companies or a lot of people, they let their patents lapse on purpose because the technology is no longer viable to the patent owner or to anyone else. In other words, the patent owner may have tried to sell the patent to somebody and he or she couldn't find any takers, so they let it lapse. And also these fees are relatively expensive, as we'll see in a future slide. So you save a lot of money by letting the patent lapse. Design patents in the US, they cover the ornamental, non-functional design of a product. Basically, how does the product look? How does it look? You can also consider trade dress protection simultaneously for the ornamental design of a product. And I'll talk about trade dress later in the trademark section. And design patents tend to be popular for consumer products like sneakers, coffee pots, stuff like that. The term of protection, a little different than a utility patent. For a design patent, it's 15 years from the issue date. So there's no measurement back to the filing date of a design patent application. There are no maintenance fee payments required after the design patent issued. Design patents are less common than utility patents. You know, compared to almost 11 million utility patents, only 900,000 design patents have issued to date. And they're becoming more important lately. We're seeing an uptick in the number of design patent application filings. That's because the owners of these ornamental designs are starting to view design patents as a good way of protecting these ornamental designs from being knocked off by others. Then finally, the third category of plant patents, which I talked about, a plant patent covers a new variety of asexually reproduced plant. The first design patent or plant patent issued in 1931, and it had to do with a genetically engineered climbing rose plant. So only about 30,000 of them have issued. So patents, they're popular because they give exclusive rights to the patent owner. And these 5 different rights are: the owner can exclude others from making the claimed invention, using it, selling it, offering it for sale, or importing it into the US. So basically, these 5 categories, they prevent anyone from trying to commercialize your invention without your authorization to do so. So the critical thing here is the invention, what I talked about in the previous slide. The word invention, it's the invention as defined in each of the claims of the issued patent. It's not the description of the invention set forth in the remainder of the patent. And we see this all the time. People read a patent, they say, well, I don't want to make what's in that patent because if I do, I'll infringe that guy's patent. Well, it's not as simple as that. You have to look at the claims, and each claim, and by the way, the claims section is located at the end of an issued patent, and each claim is a single sentence numbered paragraph. So it always starts with claim 1, then in claim 2, claim 3, etc. So that's really what you're looking for, is the claims to see if you could be possibly infringing. And like I just said, a US patent must have at least 1 claim. Most patents have more than 1. Each claim is a single sentence that sets out the technical boundaries of the invention. It basically is an objective measure of the structure or function of an embodiment of an invention. And every claim in a single patent must be related to each other technologically. So in other words, you can't file a patent application with one invention directed to a car tire and another invention to a door handle, because those are totally different technologies. Then each claim is a separate yet different statement of the invention. So in other words, you can't have 10 claims in an issued patent and have every claim be virtually identical to one another. So, and I set forth here some a sample of exemplary wording of what claim language looks like. For example, a widget comprising a first physical feature and a second physical feature that has a certain relationship to the first feature. The widget being disposed to perform the function of, et cetera, et cetera, et cetera. So you can think of a claim similar to a deed for your real property, like your house. So if you go home today or over the weekend and your next door neighbor built a fence close to the property line, you want to know, is that fence on his or her property or is it on your property? Well, what do? You take out the deed for your house and land, you look at the plot plan, you make some measurements, and you make an objective determination. Is my neighbor's fence on my property or his or her property? So a claim in a issued patent has the same purpose, is to look at that claim and decide, if I made a product that had all these structural or functional features, would I then be infringing that person's patent? Okay, so these rights of exclusion, those 5 rights that I talked about in a couple earlier slides, they do not include the right for the patent owner to practice its own claimed invention. That's a subtle yet powerful distinction there. It's another common misconception we hear all the time. The rights of exclusion, they only deal with excluding someone else from commercializing your patented invention without your permission. So what should you do if you want to make or sell a product that may be covered by someone else's patent? Let's say you're an entrepreneur, or you're a startup company, or a small company, or even a big company, anybody. What should you do? So let's take a hypothetical example of a simple chair to try and explain this. Let's assume a chair has not been invented as of yet. So you have a first inventor of a chair. That inventor obtains an issued patent with a claim that reads, a horizontally disposed seat and a plurality of legs attached to an underside of the seat. Later, someone else, in other words you invent an improvement to that same known chair. You add a backrest. Can you get a patent on this? Maybe, if adding the backrest to the previously known chair meets the patentability criteria of novelty and non-obviousness. But whether you can get a patent on the improvement is different than the next question there that says, can you make and sell your chair? Well, the answer to that is no, not while the first inventor's patent is still in force. In other words, it's within that 20-year lifetime we talked about. And this is true even if you're able to get a patent on your chair embodiment. Why is this so? Well, your chair that has the seat, the plurality of legs, and the back, it has every physical feature set out in that other patent, in the claim of that other patent. In other words, the seat and the legs. Therefore, your chair infringes the rights of exclusion given to that first inventor. And if you have a bunch of additional features, like the back, let's say you have armrests on your chairs, you have cross braces to hold the legs more stable, that's irrelevant that you have all those additional features. As long as you have every feature, structural and or functional, that's set out in the language of the claims, then you're infringing. So how do you get around this so you can make and sell your chair without getting sued? Well, you can try to design around the patent so you don't infringe. And there are 2 ways you can do that, which is, commonly people do this all the time when they're facing a possible enforced patent that poses a roadblock for their product development. You can either don't include at least one feature of the chair recited in the claim. So in this case, it seems like you can't physically do it, but you'd have to eliminate, the legs or the seat or, those are the only two structural features called for in that claim. But in the, in real world, modern situations, usually you have a lot more opportunity to not include one feature called for in a certain patent claim. In the alternative, if you can't eliminate one feature, you should try to substitute a suitably different feature for a feature of the chair recited in the claim. So let's say that the patent claim for the chair said that the chair must be painted black or be of a black color. And you're thinking, well, maybe I can avoid infringement if I just paint the chair white or the seat white. Well, that's not a suitably different feature, one color versus the other, unless there were some other advantages to painting the seat white instead of having it be black. Another way to get around the problem is you can ask the patent owner for a license. He or she doesn't have to give you one. Or you can just wait until the patent expires after the 20-year term, or perhaps keep checking on the U.S. Patent and Trademark Office website to see if perhaps the patent owner failed to pay one of those 3 maintenance fee payments that I talked about earlier. However, if you wait until the patent expires, let's say after 20 years, the technology that it talks about or discloses may be stale and thus of no use to you by then. So let's drill down to this in a little more detail. When you're trying to avoid infringement, more specific things that you can do is you want to start by searching for enforced patents for the same product or process as yours, and with claims that are broader in scope than the product you want to make or the process you want to practice. So in typical terminology, you see this as being called a product clearance search or freedom to operate search, or even a patent landscape search. And once you find those patents, you want to analyze them and compare the claims of them against what you're proposing to build or what you've already built for your product or the process that you're proposing to utilize, let's say in a factory or on a computer or something like that. And it's always a good idea at this point to get a written opinion from a patent attorney that you don't infringe the claims of the patents that you found. You may need that written opinion later on if you were ever sued for infringement to help you avoid increased damages from being found to be willfully infringing a patent. And it's a good idea to perform this search and analysis procedure of these patents before you get too far into your own product development process. If you don't find any enforced patents that are on point, then you're likely okay to make and sell your product. But if you do find enforced patents that are on point, what should you do? Well, again, try to design around them. As I said earlier, just try to eliminate at least one feature of a claim or choose a substantially different feature from one that already exists. Try to get another thing you can do is try to get permission or a license for the patent owner. You're likely going to have to pay them a fee. They probably won't give you a license for free. You can search for other prior art out there that would invalidate the patent, the claims of the patent that you found. That's entirely a plausible way to proceed. If you find any such patents, you can do one of several things. You can take affirmative steps to invalidate the patent. There are procedures available to the public and the USPTO. They're expensive, but you can file for what's called inter partes review of a patent, and you basically say that, hey, I found this prior art and I think this person's patent should be invalidated because of it. Again, you can contact the patent owner with the prior art and say, hey, I know I asked you for a license earlier, but now I found some prior art that would invalidate your patent. Let's talk about now giving me a license so I can make my own invention. Or you can merely just hold on to the prior art and wait and see if you get sued. And then if you do get sued, you can use it in a court of law to try to invalidate the patent that you got sued on. Another thing you can do is you can make and sell your invention anyway and hope you don't get sued. It's usually not a good business strategy because you're exposing yourself to possible enhanced treble damages for willful infringement. And again, you may want to engage an experienced patent attorney to help with this, because a written opinion has been found by a number of court decisions to be invaluable to helping an infringer to avoid enhanced damages. So, all right, here's a key legal concept of ownership of inventions and patents to keep in mind. Ownership of an invention, a patent application, and any issued patent resides with those persons who conceived them an invention as claimed in the patent application and issued patent. Ownership does not reside with someone who merely reduces to practice an invention as claimed in the application issued patent. I think today, with today's gig economy, where let's say you want to design a product, so you need someone else to maybe help you build a prototype, or maybe do something else to help you bring your product concept to fruition, you're hiring independent contractors to help you do this. So, and that's where conception and reduction to practice come into play here. So I'm going to try to illustrate this with a couple examples. Scenario one, Sarah invents a chair with a horizontal seat and one leg attached to the bottom. So she's conceived in her mind a specific embodiment of a chair. She then asks Mike to build a prototype. So Mike is asked to, quote unquote, reduce to practice Sarah's embodiment. Mike comes back to Sarah with the prototype. He made no changes from what Sarah wanted him to build. She likes it, decides to go into business. She files a patent application with a claim directed to that embodiment, the horizontal seat and one leg attached to the bottom of the seat. Who are the inventors? Sarah is the only inventor because she alone conceived of the structure of the chair as it was recited in the claims of her patent application. Mike's not an inventor because all he did was reduce to practice Sarah's embodiment. So she's going to be, because she's the only one who conceived of the features of the claim, she's then the owner by law of the invention, and then the subsequently filed patent application, and then any patent that issues on it. Second scenario, I changed up the facts a little bit. Same chair she invented, she asked Mike to build a prototype, but now when Mike's building a prototype, he thinks, the single leg's not a good design. You should have a plurality of legs instead to lend more stability to the chair. So he talks to Sarah about it, she likes it. She says, go ahead and build it. So he does. She likes the prototype, and she wants to now sell them in her business. She files a patent application. So now with any patent application you file, you have to name who the inventors are. Well, now in this scenario, as opposed to the previous one, both Mike and Sarah are joint inventors. Why? Because each contributed to the conception of a feature of the claim. In other words, Sarah conceived of the horizontal seat. Mike conceived of the plurality of legs attached to the seat. So now they're both joint inventors, and as such, they're both joint owners of the invention, the patent application that was filed, and any patent that issues. This may pose problems depending upon their status and relationship between Mike and Sarah. Because if you have joint owners, and in other words, there's no single company that owns the patent, or there's no one person that owns the patent, or other type of entity, a partnership, whatever. There's a couple rules here of joint ownership. One is a joint owner of a patent can license or assign, in other words, sell its ownership interest without the permission of the other owners. A joint owner can commercialize the patent. In other words, allow someone to make, use, sell, etc., the patented invention without the permission of the other owner, without having to account for any monies they received from the other owner. This could destroy the value of the patent and your business. So it's a serious situation. How do you solve it? Well, as a rule, you should avoid joint ownership of any intellectual property asset if possible. The way to do this, to avoid joint ownership, is to get ownership of inventions, patents, etc., into a single person or entity using written agreements. And many companies do this with their employees, with their vendors, with their suppliers. And really, it's a good idea to do this before the collaboration starts between the parties, like Mike and Sarah, on developing a product. All right, so let's go into the procedure for obtaining a patent in the US. Well, you start by filing a patent in the USPTO. There are two types of patent applications. There's the provisional, and then there's the non-provisional patent application. And there's only one type of design patent application if you're seeking design patent protection. A provisional patent application is simpler and less expensive to file as compared to a non-provisional. You can have informal text and drawings. You don't need any claims. The filing fees are pretty cheap. A large entity is a company with more than 500 employees who would end up owning the patent application by way of an assignment from its employees to the corporate entity. A small entity gets a 50% break on the fees. A small entity is a corporate entity less than 500 employees. A micro entity is basically an individual who has to meet certain yearly income restrictions or maximums as set forth by the Small Business Administration. A provisional, you can do it yourself, electronic filing on the PTO's website, or if you hire an attorney, usually his or her fees are relatively small. So if you file a provisional, it gives you, it expires 1 year from the filing date, which gives you valuable time to prove out the commercial viability of your invention. It allows you to say patent pending in your, that should be marketing materials. It gives you time to decide whether to further pursue patent protection with a non-provisional and with foreign or non-US patent applications. A provisional you cannot claim priority to the first provisional with, let's say, a second provisional. In other words, you can't extend this 1 year time period by trying to file a chain of provisional applications. And finally, you're not allowed to amend the disclosure in the first provisional. You have to file a second provisional instead. All right, so let me move on. Okay, continued information about provisionals. Claims are not required, but the provisional just sits there down at the USPTO offices in Alexandria, Virginia. Nothing gets examined for patentability. But here's a key requirement, which you have to take into account when you're filing a provisional. You have to kind of look into the crystal ball. And you have to disclose the invention in the provisional with sufficient words and drawings to be able to properly support the claims that you're going to later file in a non-provisional application. If you don't properly support those claims that you're going to file a few months or whenever down the road in the non-provisional, then if you have to add in additional support in the way of words and drawings into the non-provisional, that additional support is called new matter. And that new matter is a problem because any claims in the non-provisional that need for support this new matter will not be afforded the earlier filing date of the provisional application. And that can be important, not being able to have the earlier filing date because of things like disclosures and other things. Now let's talk about a non-provisional patent. Okay. application. It's more formal than a provisional. You need formal text. There's all kinds of margins, font requirements. You need formal drawings with strict requirements. Usually you hire a professional and do that. There's plenty of drawing firms out there in the US and outside the US that'll do that for you. You need at least one claim covering the invention that's going to be examined. But typically you file it with more than one claim. And the non-provisional may claim priority to one or more prior filed provisional application. But the 20-year term of the patent that would issue on a non-provisional, that 20-year term starts with the actual filing date of the non-provisional application, and it does not start with the filing date of the provisional application. I got a small typo there. Should have added the word with here. All right, let's continue with non-provisional. It's more expensive to file. You can see the fees are a lot more. You can still do it yourself. And if you do decide to hire an attorney, usually his or her fees will be greater than what they would charge you for the provisional. The non-provisional gets published at 18 months after the earliest filing date. So if you filed a provisional application first, and then you file the non-provisional, let's say 12 months later, then 6 months after you file the non-provisional, that will be published. And like I said earlier, it's most likely the non-provisional will not have issued as a patent by then. So some of my clients that I've seen over the years, some people, they don't want applications that are still pending to be published because they just want to keep everything in secrecy. So you can ask when you're filing the non-provisional, you can request the PTO not to publish it. Once the application is filed, the non-provisional, it gets assigned to an examiner at the PTO. That examiner is supposed to have some technical experience in the subject matter of the non-provisional patent application. After several months or more, the examiner examines each claim for patentability, for the criteria of novelty, non-obviousness. You know, the biggest complaint we see is that the USPTO takes too long to examine a patent application and issue a patent. So there are ways of speeding up the examination process. Usually it takes paying extra fees to do so. There's other criteria you can meet that's less expensive for speeding up the process. For example, if you're at least 65 years of age as the inventor, you can ask the PTO to speed up the process. So then once the examiner examines each claim of the application, he or she decides whether to issue a patent or to reject the claims. If he or she rejects the claims, then you got to respond as the applicant. This could go on for numerous iterations. It takes a lot of time and money to do this. So that, you know, if you're finding it hard as the applicant, you're finding it difficult to get a patent issue, you may want to decide whether it's worth the time, effort, and money to continue trying to get a patent on it. Some more information about non-provisionals. Again, the common complaint is that the PTO takes way too long to issue a patent. But if you're fortunate, you get the examiner to agree with you that a patent should issue on the claims of your application, then you have to pay issue fees. And these are what the current fees are for the 3 different entity sizes. And then earlier I said, after the patent issues, the owner must pay maintenance fees 3 times. And you can see the fees get very large, especially as you hit the 11.5-year mark after the patent issues. You're talking about a lot of money, especially if you're a large corporation. Let's talk quickly about procedure for obtaining a patent outside the US. Contrary to popular belief, there is no one single international patent available throughout the world. There is this Paris Convention, which is an international treaty. Most industrialized countries are members. Basically, what it allows you to do is file a patent application outside the US within 12 months of the earliest US filing date, be it a provisional or a non-provisional filing date. And then that foreign filed application will automatically receive the earlier US filing date. And you can either file directly in the patent office of the desired country, or you can file a regional application in the European Patent Office for all of the European Union member countries. These are rough rule of thumbs of what it costs to file. But again, it depends. How much you pay depends on how voluminous is your patent application. Does it have to be translated from English into the native country of where you want to seek patent protection, etc. Or let's say if you want to get patents to issue in Europe, you can file in the patent office of each EU member country. The rule of thumb that everyone likes to use is that if you're trying to obtain patent protection in 3 different EU countries, let's say Germany, UK, and France, and then maybe others besides that, then a good rule of thumb from a cost perspective is file a single EPO regional filing application. And then there's been talk, it's been talked for a number of years, but there's talk about a single unitary patent coming to the European Union in 2022, but we'll see. It's still, nothing's definite yet. Another way to achieve or seek patent protection outside the US is to file what's called a PCT, or Patent Cooperation Treaty application. PCT is administered by the World Intellectual Property Organization in Europe. You file 1 patent application in a single language. It does not result in the issuance or grant of a patent, but it buys you time to decide where you want or need patent protection outside of the United States. And a big advantage is it lets you, as an individual entrepreneur or startup or even a small company, it lets you defer the bulk of your costs to a later date. And then if you decide to quit with your PCT application, you can then avoid having to pay these later on costs. So it gives you a chance to really determine the commercial viability of your product or process that you're trying to get a patent on. Some more features of the PCT. So within 12 months of your first application filing, let's say in the US, you file a PCT application either in the US Patent and Trademark Office or somewhere else, the EPO or the Japanese Patent Office, etc. About $4,000 to file, plus attorney fees. And you can designate as little or as many up to 153 member countries that you're just thinking about getting patent protection in. You don't have to make a hard decision when you file the PCT, but if you're not sure which countries you want to ultimately seek patent protection in, it's probably best to check as many as possible, and then you can then back away from those certain countries later on. When you file a PCT application, you will receive a search of the claims of your application against the prior art, and you can also request an optional examination of those claims. And you get back a search report and then a examination report, and that's helpful in allowing you to decide whether to seek patent protection in various countries. You won't get a PCT doesn't result in any kind of a patent issuing when you exit the PCT process 18 months after you file the application. But if you still want to get patent protection after PCT expires, then you have to file national applications in the individual countries, for example, Germany, UK, France, China, wherever. I'll touch on public disclosures of inventions. As an individual entrepreneur or startup, you should be mindful of any planned or actual public disclosures of your invention. A public disclosure will start a 1-year grace period. Within that time, you have to file an application in the United States Patent Office. But that to be deemed to have started the 1-year grace period, that public disclosure has to be in enough detail to convey your invention so that one of ordinary skill in the art understands it. Many countries don't have this 1-year grace period. For example, European Union countries. Instead, they have a more prohibitive, what they call an absolute bar to patenting your invention in those countries. So in other words, if you publicly disclose your invention in the US to someone who's under no obligation of secrecy to you, and you haven't filed a US application first prior to your disclosure, then you face the harsh reality of not being able to file that same patent application in these other non-US absolute bar countries. So it's a harsh result, but it's one that's there and has to be kept in mind. A public disclosure can also include a sale of a product embodying your invention or an offer to sell. If you must publicly disclose your invention, you should wait until after you file a patent application, or try to use non-disclosure agreements as much as possible to mitigate the public aspect of it. Here's some strategic patenting considerations. In the interest of time, I'm going to move through some of these. Talks about performing a prior art search, prior to filing in the patent application. Think about the scope of the possible claims you could attain if you file the patent application. How crowded is the prior art that you're uncovering? What's the likelihood of commercial success of your product or process? If you were to get a patent, where should you file for patent protection? For example, your production or manufacturing locations, are they here in the US, or are they going to be in China or Europe or somewhere? Where do you sell your product? Where are your competitors located? The cost to obtain patents, your willingness to enforce, or your willingness to license or sell your patent. I'm going to be presenting more detail about patents on December 10th in a VVM workshop. Let's move to trade secrets. The definition of trade secret is any info that gives your business a competitive advantage over other businesses who do not know that information. So basically, it's information that is secret to a business, and it provides economic value to that business. Here are some examples: customer names, pricing, customer buying preferences, which are important to retail type businesses, supplier names and pricing info, computer program algorithms, recipes, ingredients, processes. Trade secrets are also commonly known as know-how or proprietary info or confidential information. Legal protection theoretically lasts forever if the owner takes steps to keep it secret. So if the info remains secret, then the legal protections afforded trade secrets will continue indefinitely. There's no registration or examination process needed to create these legal rights. The rights begin automatically upon the creation of the info. Governed primarily by state laws, but there are some federal laws, or a federal law that jumps in as well in certain instances. Massachusetts just revised their trade secret laws a couple of years ago. I'll skip down to federal law, which is new. It's been modified as of May 2016. It's now referred to as the Defend Trade Secrets Act. You now have a federal cause of action if someone misappropriates your trade secrets, but it really only applies to dealings that you have as a business with other businesses that are in interstate or that are in other states. So it's interstate or foreign commerce. In other words, you have an issue with someone up in Canada or Europe or somewhere like that. And it also, this new DTSA under federal law provides an extraordinary remedy where it allows the trade secret owner to seize property necessary to prevent the propagation or dissemination of your trade secret. So for a trade secret, you as the owner, you must take steps to protect the info. So you must know of and keep track of all information that you believe to be a trade secret. Use proprietary markings on documents and signs. Restrict access to facility or within facilities. Limit physical and computer access to only people that are need to know. And remind your employees of the existence of trade secrets and your expectation of maintained secrecy by them. For example, have them sign documents like employee handbooks so your employees acknowledge the existence of trade secrets and their obligation to keep them confidential. And use confidentiality contract terms with suppliers, customer vendors, etc. Continuation, you have today's mobile employment environment. You have employees coming and going all the time. So departing employees, you should remind them of the prohibition on disclosure and use of your trade secrets. These departing employees, by law, they can take and use general information at their new employer. Obviously, they have a right to make a living, but on the other hand, they can't take and use your trade secret info at the new employer to your disadvantage. And this also implicates non-compete contract clauses as well. On the flip side, you want to hire an employee. So be mindful of, for example, where are they coming from? Are they coming from a competitor of yours? For example, if you're trying to start up a new autonomous vehicle company and you're going to hire away someone who is a top designer at Tesla, let's say, you know, there's implied or an implication that that person is coming and might be using trade secrets of Tesla in your company. Also, you know, what trade secrets of the former employee may they know? You can't obviously ask your new employee, hey, what do you know? But, you know, you can get a sense for what you think they might know. And then there's this inevitable disclosure doctrine, which says that, let's say, go back to the example of you're hiring someone from Tesla. It's highly likely that this person from Tesla will likely disclose trade secrets of Tesla after they join your company. So you're running the risk by hiring this person of Tesla suing you to stop any imminent disclosure and use by you of their trade secrets. Trade secrets, also considerations. How easy is it to reverse engineer the information that you consider to be trade secrets? It is perfectly legal for someone to buy your product and reverse engineer it. How easy is it to for someone to independently develop your trade secret information? Again, it's perfectly legal for someone to independently develop that same information. Trade secret legal status is lost once the information becomes generally known, either by reverse engineering or independent development or authorized disclosure by you. You can sue someone for theft of your trade secrets. Available remedies include injunctive relief and money damages. The bottom line is your trade secrets may be difficult to adequately protect. Trade secrets are closely related to patents. The main difference is for trade secrets, there's no requirement that you must publicly disclose as there is for patents. Remember, in a patent application, you have to disclose the embodiments of your invention. Certain trade secret information can rise to the level or can be considered patentable subject matter. For example, machines, article manufacturers, compositions of matter, process, or methods. So you have to decide in a situation like that where something could be patented or you could keep it as a trade secret, you got to decide which way to go. Do you want the theoretically infinite life of a trade secret, or do you want the 20-year life of a patent? How easy is it to protect the trade secrets with safeguards? How easy for someone to reverse engineer or independently develop? What's the expected life of the technology? Can you use that technology with different products in the future? What's the anticipated commercial viability of the product? Let's talk about famous examples of trade secrets. The formula recipe for Coca-Cola or Kentucky Fried Chicken. So the formula recipe for Coca-Cola was created in the late 1800s. I think it was 1894. Coca-Cola could have filed for patent protection when they created the formula. They could have filed it under the category of a process or a composition of matter or both. Any patents they would have obtained would have likely expired in the early 1900s. And then the patents would have provided a roadmap for anyone wanting to make Coca-Cola. And once these patents expired, anyone could indeed make Coca-Cola without having to compensate them. And as we know, competition lowered prices. So what Coca-Cola did was they chose to keep the formula as a trade secret. Supposedly, according to folklore, it's stored in a vault in Atlanta. Only 5 people have access to it. If you're a licensed bottler, you don't get the formula. You only get the syrup that Coca-Cola makes for you. And people have tried over the years, but they can't figure out how to reverse engineer Coca-Cola. The bottom line is they kept their competitive advantage by keeping the formula a trade secret. How are we doing on time?
It's 3:23.
Okay. I still got a couple more sections to go.
Could I ask a quick question, Rick?
Sure.
Really been enjoying this. Thank you. I was just curious if a supplier relationship or a supply chain in general could be a trade secret in terms of employees coming and going to competitors specifically.
Yes, most definitely. Yeah. If it's information that only you know it and it gives you a competitive advantage,
Right.
then it can be considered a trade secret.
And how kosher is it to have employees sign something like a non-disclosure or what are I wasn't sure if I understood exactly how can we safeguard those types of things without being,
Well, yeah, with employees, you can have them sign confidentiality agreements or non-disclosure agreements. You can inform them that, hey, we have trade secrets here in this business. We expect you to keep those trade secrets confidential. You can't disclose them to anyone outside this business. You can't use them to our disadvantage. So, when you have captive audience like an employee, then non-disclosure agreements, or AKA confidentiality agreements, they're proper to use. It's when you get into a situation where you're going to some kind of a conference or trade show and you've been asked to give a speech to a room full of people, you can't realistically ask every one of those persons to sign a non-disclosure agreement.
Right.
So you have to make a decision. Is it worth me going and giving that technical paper and spilling the beans on our proprietary info or trade secrets at this conference?
Right.
Is it really worth it?
Would it be, and I don't mean to hammer this too much, but we've been considered having it be part of an onboarding experience that you're signing something that, over the course of your employment, you'll learn certain things. Yes. And we expect that you'll keep it confidential if like during your employment and or after your employment. That's that's normal. Okay.
Yes, it is. Well, I mean, it also depends on the level of employee as well. For relatively more simplistic jobs that you're having someone do, it may be difficult and it may not be normal to have that person sign this type of an employment agreement. Although, in the modern day times, it seems more and more employees of any importance or level of importance or degree or job functions, they are being asked to sign agreements because of the nature of what they could be exposed to. So, yeah, I would say that, if you can, try to get every employee coming in the door, regardless of job function, have him or her sign confidentiality restrictions, of the type you just mentioned. You will be exposed to these. We expect you to keep these private and confidential. If you leave us, you can't use them at, other employers because it's really our proprietary info. So.
Got it. Thank you. That's super helpful. Thank you. And I'm excited about trademarks. We have some questions for you after this section too.
Okay. Hope you want me still, I know it's almost 3:30. You want me to keep going?
Oh, my bad. That's fine.
Well, Katie, are you good to wait? Are you good to go over a couple minutes? I know we started a few minutes late, so I don't know. Could we go a couple minutes over? And
Yeah, I can go.
A long presentation, so I have no expectation that you should continue. That's fine. I actually have someone coming at 3:30 anyway. But maybe we could just ask a couple questions about trademark.
Sure.
I don't know.
Well, let me, is Diane still on?
she had to jump off.
Why don't we do this, Hope? Can we schedule another session where I can go through trademarks and copyrights? Let's say for another hour or so, let's say after Thanksgiving or something like that.
Oh,
Yeah,
But-
I think that would work.
But in the interest of answering questions on trademarks, yeah, let's spend a few minutes here if we can.
Okay.
A couple minutes before Katie has to drop off here.
that's so kind of you. Thank you. This is my partner, Carlos. We work together.
Hi, Carlos.
How you doing?
Carlos.
I'm good. How about yourself?
All right.
Oops. So we have a custom screen printing business, but we also do original prints and sell direct to consumer. And there's a couple of like slogan phrases type things that we've been curious if it was worth trademarking. And I guess my question is like, what does that decision tree look like? Because I assume it's not, from my understanding, it's like a couple $100s to trademark a phrase, but maybe it gets more expensive.
What it is once you adopt any kind of a trademark, be it a word or a phrase or a slogan or a logo or design or even non-traditional things like colors, smells, other things. Once you adopt a mark and you start using it on goods or services, and you provide those goods in interstate commerce, or you advertise the provision of services in interstate commerce, then you automatically get federal common law trademark rights. So you can start using the TM superscript that you see a lot after the slogan or after the word or after the logo. And you can also file for registration of the trademark with the USPTO. And the way that works is you can do it yourself. It's not too difficult to do. You do it electronically. You file it electronically on the USPTO.gov website. The filing fee it's either $225 per class or $275 per class. And the distinction is, and when I say class, there's 45 different classes of goods or services.
Yes, yeah. I think we started that process.
Yeah, you have to pick, depending on the goods, you have to pick one or more of those classes that you want to register the mark in. Whether you're selling goods or you're also providing services, you could end up with 3 or 4 or more different classes. So for each class, it's either $225 per class or $275 per class.
Yeah.
And if you go the lower price $225 route, you have to pick a description of the goods or services, which is a standard description determined by the U.S. Patent and Trademark Office that's set out in what they call their ID manual of goods. So if you can find, an already canned description of the services or goods or both that you're providing, then when you file the application, you're just picking that description. In other words, you didn't change it at all and made it an original description to you. On the other hand, if you can't find a canned description of your goods or services, then you can write your own description, but you now have to pay the higher $275 price tag.
Got it. Yeah.
Goods or services.
We got as far as that, and then we didn't continue because we weren't sure. So basically, specifically, there's like this, it's not the name of our business, but rather different phrases that we use that are
Yeah.
regionally important. So outside of this region, I don't think any competitor would be interested. It just wouldn't be valuable. It's something specifically about Western Massachusetts. But there are other people in our community who have started to use the phrase, and we definitely created it. Like, we have the first hashtag on Instagram with the
Yeah.
phrase.
Yeah.
And we don't really care. We don't want to like sue any, we don't want to be the only ones who can use this phrase, but we
Right.
do want to not be prevented ourselves from using it. So
Right.
even though it's not going to be something lucrative that anybody outside of Western Massachusetts would care about, should we still do it, I guess, is the
Yeah,
decision.
if it's doable financially, I would say yes, do it. If you know, if money's an issue, whatever, I then still you can rely on your common law federal rights. You can also file for a registration just in Massachusetts.
Right.
That's a lot cheaper. It's only $50 per class.
Hmm.
You get a registration issue a lot quicker than a federal registration, which best case takes about 9 months right now to have it issue. If you don't run into any problems down the
Interesting. Okay, so
trademark,
we could do
it
it.
takes about 9 months. A mass registration will issue. I haven't filed one in a while, but it was only taken about a month or so a few years ago. Maybe quicker now, maybe slower. I don't know for sure, but it's only $50 a class. But that registration only protects you in Massachusetts.
Right,
So,
which I think is the only territory that it would matter.
yeah.
Okay.
Yeah, the problem is, we're so close to Connecticut, New York, Rhode Island, New Hampshire, Vermont, that a lot of businesses right here in Springfield, they are selling goods to these neighboring states, or they're providing services to the neighboring states. So,
Yes.
I advise them to go right to the federal, to get a federal registration and
But
try.
the state registration would govern who can sell it in Massachusetts. So if someone's making it in Connecticut, they still can't sell it in Massachusetts. If we have
a federal registration, if you get it, that means you're the owner of that mark. You have the right to use it throughout the entire United States on those particular goods and services. So, and it's evidence that you were really the first one in time to use it. So if now someone comes along and they're essentially stealing your slogan and using it on the same identical or similar goods or services, you can write them a letter, cease and desist letter, and say, hey, here's our registration.
Right.
Stop. Or if you don't get the registration yet, you can enforce your common law federal rights, and you can still send them a cease and desist letter and say, hey, you better stop using it. We were first in time. And there's also another area of the federal trademark laws. It's called the unfair competition section, where if someone is violating your federal common law trademark rights, you can go after them also for under the unfair competition portion of what's called the Lanham Act, LANHAM.
Okay. And for the common law federal rights, how are those claimed again?
Just put a TM superscript after the slogan. Okay. And then maybe somewhere else on your marketing materials, for example, the website or any printed documents you have, you put like, put the slogan, whatever it is, and then put TM after that, and just say, you can say something like the slogan, whatever it is the trademark of whatever your company name is, all rights reserved, something like that. So if it was Coca-Cola, you would say the Coca-Cola name and logo are the trademarks of the Coca-Cola Corporation Incorporated, all rights reserved.
Yeah. So, and then for the state, and I know we're already over time, but for the state trademark registration, is that through the corporation?
The Massachusetts Secretary of State's office, William Galvin's up.
Yeah.
If you just Google Massachusetts trademarks, it'll take you right to his webpage, and it has a pretty good description of what to do. It's fairly simple. You can pay by credit card, I believe, just like you can, if you wanted to file for a registration at the USPTO, you pay by credit card.
Cool.
It's a little, their e-filing system gets a little wonky at times down at the USPTO, but if you stick with it, you can do it.
Okay, got it. Well, that's super helpful. Thank you. I have a whole nother section of questions, but I'll save it for the other section later on. Thank you so much for being so generous, Rick.
No, no problem. Thank you. Thanks for joining in.
Yeah,
Thanks,
you so
Hope.
much, Rick. Thank you,
Nice
Hope.
Bye-bye.
Thank you. So good to see you.
You too.
Yeah, you
and hope to see
too.
you soon. Saludos to Chris.
Okay. Bye-bye.
So,
I'm gonna